So we did come to, we have 57 motions. We've got the week set aside. And depending on how it goes, I don't know. Whose is this? I'm gonna move this so I can see what I'm doing. Okay. I'm not trying to mess with your audio, sir, but I've only got so much room up here. All right. So this is 23 SC 189192. State versus, we have four defendants, 61 folks. I'm not going to read out all 61. But on today's calendar, we have Francis Carroll, James Lee Mariscano, Alexis Papale, and Spencer Liberta. And I have Mr. Schwartz. I don't know why it's still showing up as Mr. Kissler. Mr. Dejanon for Mr. Mariscano, Mr. Hetzel, Hetzel for Papali, and Mr. Kazicki for Liberto. All right. Okay. And the first motion we have is, we have demurrers. The first one we have up is defendant Papali's motion to have the defendants demurrers is to count one, all of them heard. We're gonna hear the four that are here. So the first one I have is Mr. Papali's general and special demurrer to count one of the indictment. So, Mr. Hetzel.
And I apologize, before we begin, could we just ensure that each defendant is on Zoom? I see one that says Frankie's, I assume that that's Mr. Carroll. I can't tell anybody else just from my screen. I don't know if anybody else can see them. I can't.
Fair enough, fair enough. Do we have, I see, is Francis Carroll, is that Frankie?
Yes, Your Honor.
Can I get him to turn some video on, please? Is Mr. Mariscano here?
Yes, my client is.
Please stand. Thank you, sir. You have a seat there. Mr. Papali?
Here, Your Honor.
Thank you, sir. And Mr. Liberto?
Yes.
Thank you, sir. All right. All right. And I see lots. I have a full jury box. I'm sure one or the other of these parties would love to have that jury. But first off, we have Mr. Papali's general and special demurrer to count one. So, Mr. Hetzel, the podium is yours, sir.
Thank you, Your Honor.
And Mr. Papali does need to turn his video on.
Mr. Carroll, Judge.
Mr. Carroll, I'm sorry.
Passing that message.
Okay. Well, I thought I was passing it by staring at the screen and saying, Mr. Carroll, turn your video on.
And while we're waiting, Your Honor, may I invoke the rule of sequestration for any future witnesses?
Absolutely. Thank you, Mr. Carroll. If there are there any witnesses that are going to be testifying? Mr. Hetzel? Okay. I'm just going to go down the line. Mr. Kazicki, you going to have any witnesses?
No witnesses, Your Honor.
Mr. Dejanon?
Yes, Your Honor.
All right.
And I can ask them to step out.
Mr. Schwartz? No, you don't ask him. I tell him. Okay. If you are intending to be called as a witness in this trial or in this hearing, I'm going to ask you to leave at the present time. Do not discuss your testimony with anyone outside in the hall. Once you have completed your testimony, you are free to remain or go out about your way. But if you do go out and about, I'd ask that you not discuss your testimony. And when I say ask, I mean I'm telling you, do not discuss your testimony with anyone. Thank you very much.
And if I may, Your Honor, if I'm waiting for a witness, I don't know if she's here. If I could call her. I just never met her in person, so I'm not sure if she's here. Is Miss Paige Singer here? And that's all my witnesses here.
Okay. All right. The rule has been invoked. All right. Mr. Hetzel.
Morning.
Morning.
For a point of clarification, are we skipping my motion to have all general demurrers and special demurrers as to count one per for my client's trial?
Yeah, I am hearing y'all's for. that's what I'm doing. I kind of let everybody know that I'm now with the understanding, because we have 200 and some odd predicate acts, predicate slash overt acts. Mr. Schwartz was kind enough to go through each and every one of them in his motion. So I have seen that, and each, your clients are named in some and other folks are named in others, and whether or not that ties in and provides sufficient nexus, et cetera, we'll cross those bridges when we come to it.
And then additionally, we did file specifically joining two general and special demurrers, one filed by Tom Samuel, one filed by John Gardner.
I see Mr. Samuel here. Lovely reading of the Kimbrough case. Thank you very much. I also have for the record, Mr. Samuels had his heard in front of Judge Adams, and I believe the order was issued in April, March, Mr. Samuel?
Judge Adams' order within the day that we had our initial appearance with you.
That's right, in May, and you have filed a motion for reconsideration.
It's both reconsideration that there were, most of our issues were not addressed.
Well, I've read the transcript, so it won't be heard for the first. I've read the transcript. So, go ahead.
As to our your file on behalf of my client, Howard Scapelli, we specifically want to point out a date range issue, which is that we demurred to count one as being imperfect in substance and form, because the state provided a date range which preceded the acquisition by the city of Atlanta of what would eventually become the training center, which we believe is the crux of this case.
Just pull that line.
I can't. Does this help?
And hold on one moment, Mr. Hetzel. I can't connect. So, I'm sorry, Mr. Forte is kind enough to give me real time up here, and it's just not connecting. So it's what the delay is. It's like magic. Thank you, Mr. Forte. Now, obviously, we've got a whole bunch of cameras here, and I appreciate the public interest. But you guys come in and please coordinate with our folks, because your sound equipment is affecting his ability to do his job. When you tie your microphone around our microphone, he gets nothing but feedback. So I see a mic wrapped around Mr. Hetzel, and I know this is none of your doing. No, you see where there's a microphone wrapped around the microphone right there?
Oh.
Yeah. Whose microphone is that? Anybody going once? That's yours? Fix, please. He's got to be able to do his job. Thank you, sir. Now, Mr. Hetzel, you were saying, The date range provided by the state predates the acquisition of the land that is the gravamen of this indictment.
I was, Your Honor.
Okay.
Yes.
And do you have, just for the court's curiosity, what date was that land acquired on?
So the indictment dates the beginning of the criminal enterprise or the alleged criminal enterprise to May 2020. However, it was not until the following year, September 2021, and I will provide the court with a URL link, which is https://4//tinyurl.com/2NWE, which was the city council meeting notes and actually timeline that ultimately resulted in the land swap, which began the process of construction of a training facility. And as I am pointing out in paragraph 4 of my general and special demurrer, the indictment fails to narrow the date range, and as State v. Layman 279 Georgia 340, which is a 2005 case, says that an indictment is not perfect in form and is subject to a timely special demurrer when it fails to allege a specific date range. There is an exception to that, Mosby v. State 319 Georgia App 642, that's a 2013 case, which says that the exception exists only if the state presents evidence that it cannot reasonably narrow the date range. There are other cases that I may bring up, but at this point I will turn it over to the state to see if they have a witness who could provide evidence that they could not more reasonably narrow the date range.
Mr. Fowler? Or, I'm sorry, I don't know which one of you is handling this one. Is this going to be you, Mr. Fowler? Or?
Basically, there are a lot of things that overlap in these arguments in the demurrer, so that's why we're doing it.
Excuse me. So Judge, as to the first allegation or assertion that the defendant makes in this regarding when we allege that the conspiracy began or that the enterprise began, I'm just going to point out that that's really, their argument is can we prove what we've alleged? And so, because we're here on a demurrer, what did we do? We said in our indictment that based on the evidence that we have, the enterprise began in 2020, in May of 2020. Now, how are we going to prove that? That's really not a question for demurrer. I'll go ahead and tell the court, though, that we believe we will be able to do so. In fact, I can throw out a couple of facts for the court. One, there was a co-conspirator that said it began in 2020, in that summer or around that spring, May-ish. And two, the Networks for Strong Communities, which is thoroughly alleged in the indictment as the funding source and part of the organization of the enterprise, actually was incorporated in August of 2020. So basically, Judge, the issue of how are we going to prove that it began that early, it's an issue for trial and not an issue for demurrer. Additionally, the other argument they made, Judge, is is whether we sufficiently narrowed the date range. And I'm just going to point out, this is going to overlap, and I hate doing it this way, but the reality of it is that in one situation and out of one side of their mouths, they're saying you have to prove continuity, which means you have to prove years and years and years of racketeering activity. And on the other side, they're also saying, but you didn't narrow it enough. And those two things are completely inconsistent. We have narrowed it according to when this conspiracy began and when they got indicted. That's all we have to do. We have to prove what we do have to prove, not continuity. We do have to prove a pattern of racketeering activity. The allegations in this indictment, not proof at trial, the allegations in this indictment thoroughly establish and set out how the pattern of racketeering activity began in, or the enterprise, excuse me, began in 2020 and continued on through 2023. The case law cited by the defense has nothing to do with RICO. The case law that I've seen cited by the defendants in this case, multiple defendants in this case, about narrowing the date range are child sex abuse and incest cases. Completely different factual situation where the courts have said, no, you can't argue a pattern. You have to specifically allege, essentially. And what we've got here is an affirmative obligation on the part of the state to allege a pattern, which means a course of conduct over a period of time. And we didn't determine how long it went on. In fact, we would have much rather it been shorter. They determined when it went on. We've specifically alleged, as overt acts and predicate acts, with particularity, different dates that different overt acts and predicate acts occurred. So, Judge, we are not, the state's position is we absolutely cannot narrow the indictment or the conduct to a narrow or a more specific date and time because their activity spanned this entire period of time, and these specific dates of particular overt acts and racketeering activity are alleged in the indictment.
Okay. So to me, that sounds like while the Department of Public Safety building or the training facility is a large portion of this indictment, it is not the only thing in this indictment. Therefore, they are saying we're not bound by when that land was swapped or acquired. We have a date range that we gave you, and that's the date range we're going to have to prove.
And allege, yes, Judge.
Well, allege and prove.
And prove, yes, eventually, yes, yes.
So they're saying the conspiracy is bigger than just what happened with the land and the land swap.
Well, and Judge, understanding too, and Mr. Fowler can probably speak more to this because he was involved at the outset of this a lot more than I was, to be completely candid with the court, and has more knowledge, about the inner workings of it and how it came to be, if you will, in the big spectrum of the police, of the Public Safety Training Center. But I will say that way before the announcement and before the city council meeting, there was obviously actions, discussions, and conversations in the works. And quite frankly, based on the evidence we have, for example, there's evidence of threats, and damage done in furtherance of this conspiracy before the announcement was ever made. So obviously from that, you can deduce that our evidence will show that whenever the government made it official, is not really the question. It is when they started acting and when they developed their intent. And that is what we've alleged, started in May of 2020, and we believe we'll be able to prove it at trial.
Okay. Mr. Hetzel?
What we've just heard is a proffer, Your Honor, not evidence. I'm going to direct the court to State v. Gamblin, 251 Georgia App 283. That's a 2001 case where the court held that absent some showing by the state that its evidence does not permit it to identify the exact dates of the crimes, we must conclude that the indictment counts in question are imperfect and thus subject to special demurrer. In other words, the burden, since the date issue has been raised, is shifted to the state to provide evidence of whether or not it can narrow the date range, not a proffer, evidence. in the form of testimony. I will note that the state also said that many of the cases cited are in the realm of child molestation, and that is accurate, but not all of them. I'll direct the court to Cole v. State, which is 334 Georgia App 752. That was a Medicaid fraud case. And just going through a few different cases, including cases that involve child molestation, that stand for the proposition that without the state showing through evidence that it could not further narrow the date range, it is subject to a demurrer. State v. Meeks, 309 Georgia Act 855, where the trial court granted the demurrer and the Court of Appeals affirmed because the state failed to demonstrate an inability to narrow the range of dates. We can go to Mosby v. State, 319 Georgia App 642, a 2013 case. The trial court denied the demurrer and the Court of Appeals reversed and granted the demurrer because the state relied only on its argument that the date range exception applies. It did not provide evidence in support of that, which is similar to what we're at this point looking at here. That case quoted Blackman. See if I have a citation for Blackman.
You're going to give me a minute to read all these cases, Mr. Hensel?
If you would like to, I will sit down right now.
Because I think you've just rattled off 1, 2, 3, 3 plus the one I'm reading right now.
I'll take a seat. Let me know when
Now that being said, I did have a fun time reading this weekend and I did not see those cases in here. Otherwise, I would have looked at them. Fair?
Fair.
Um,
I didn't anticipate a quibble over whether or not the state would need to present evidence that it couldn't narrow the date range. I thought that was pretty settled and established, but fair that I did not provide citation.
that was okay. That was a judge. I didn't think you'd have to think about it. It's so obvious anybody would know this.
I mean, I haven't heard counter citations, Your Honor.
Fair. And this is from the gambling case. Instead, we, like the trial court, are bound by the record before us. And absent showing by the state that its evidence does not permit it to identify the exact dates of the crimes, we must conclude that the indictment counts in question are imperfect and thus subject to a special demurrer. Is there a difference between, hey, we gave you a 2-year range, or they gave you specific dates in the indictment from this date to this date? They didn't say a span of this year. The indictment is the indictment. May 25th, 2020 and August 25th, 2023.
That's a
So
date.
they're alleging a specific date of May 25th. With more interested in this one. Which one was your Medicaid, the 251 or the 334?
Medicaid is Colby State, 334, Georgia Ave, 752.
And I'm looking at the Cole case. Indicted for offenses of Medicaid fraud over a date range beginning November 1st, 2010 through December 27th, 2013. True test of the sufficiency of an indictment to withstand a special demurrer is not whether it could have been made more definite and certain, but whether it contains the elements of the offense intended to be charged and sufficiently apprises the defendant of what he or she must be prepared to meet, and in case any other proceedings are taken against him or her for a similar offense, whether the record shows with accuracy to what extent they plead a former acquittal or conviction. It is useful to remember that the purpose of the indictment is to allow defendant to prepare his or her defense intelligently and to protect him or her from double jeopardy. The court agreed that the trial court erred in overruling special demurrer. Mr. Hetzel, I get the date range. I get what you're saying there. And I have Which of the multitude of microphones is blowing my court reporter's ear? Okay. How you doing, Mr. Forte? Is that a problem? Okay. I would note that of the multitude of overt acts in count one, all have specific dates on them. Does that not satisfy your specific dates within a date range?
Your Honor, I would note that an indictment is not evidence. The burden is for the state to provide evidence that they could not narrow the date range.
Well, their date range runs from the date of the first of the overt acts. I mean, they listed a date range that is on the edges of the overt acts. Is that not specific dates?
Your Honor, I think we're parsing, but what I'm going to point out is the cases that I've referenced, starting with gambling, has specific dates. It has July 1st, 1998 through July 31st, 2000.
Yeah, that's a date range.
Right.
And we agree on that. And you're saying, count one says March 25th or 21st, 2020 through August. Right. And then within the same count, it lists specific dates that make up that date range. That's where they get the date range from.
It does make allegations. Yes, Your Honor. What
So
I'm
if
asking,
they had listed the overt acts as individual counts, just for sake of argument here, and each of those overt acts had a specific date, we wouldn't have a special demurrer problem. But if we collectively put all those dates together and make a date range out of it, then we have a special demurrer problem?
we have a date of May 25th, 2020,
Mm-hmm.
which is a year and a half before the land swap.
Mm-hmm.
This is an allegation.
Mhm.
The state is saying that it ties in with their one count RICO count. If they can present evidence to that effect, we may not have a demurrer issue. I'm merely asking for them to provide and for me to be allowed to examine whoever they bring to testify to give their date range basis. In other words,
See, here's where I think we're not communicating is, again, you focused on the land swap deal. What the state has said is this indictment incorporates more. This is not a land swap deal indictment. This is a RICO that is inclusive of that. It includes that issue, but that's not the entirety of the conspiracy.
and when we talk about getting into other demurrer issues and the sloppiness of the situation, we have amorphous titles called Defend the Forest, but also that this.
I've read, you're getting ahead, but yes, I hear you.
Okay, so.
Night of Rage, et cetera. Yeah. I got you.
So if it's just people don't like what somebody's doing and they're protesting and we're deciding that's criminal, well, that's a whole different conversation that we're going to be having.
Okay, well, your argument has been heard on the date range. Now, that being said, the first date alleged in the overt acts portion of count one is July 5th, 2020 versus March 20th.
March 25th,
March 25th, 2020. There is no March 25th
Over that.
overt act. State, what do you got to say about that? Anybody?
Thank you, Judge, and good morning. I'd like to note a couple things up front. I know that counsel has indicated that he wishes to see evidence. I would point the court, as this court has already indicated and as counsel indicated, the counsel proffered. We are permitted to do that under Georgia law, under State versus Battle. It's at 812 SE 2D1. Proffer is sufficient where a defendant does not timely object. Counsel did not timely object during counsel's argument, and therefore the proffer is sufficient.
I'm going to object, Your Honor. I don't know how I would be objecting during my argument. If he meant that I did not object during the state's argument, I want clarification.
He objected as soon as the state sat down. He went, "Hey, Your Honor, that's not evidence." That was pretty contemporaneous.
The court may find contemporaneous. I have a witness outside who is ready to go on this issue. But that said, what you have to do is during the evidence is you have to object and say, this is not evidence. We don't accept the proffer. You object during that, and then you don't wait till the end of the argument. Because at the end
Then
of the
I'm going to
argument,
object again, and I'm going to note
No,
that
no,
even
no, no,
during the
no,
proffer,
no.
I didn't hear
Mr. Hetzel,
anything
Mr.
proper.
Hetzel, sustain. No, Mr. Fowler, he objected, the court's going to find he objected in a timely fashion.
I'm just going based upon what Court of Appeals has told us on that. But going to the dates issue, this court is correct. The indictment outlines each and every individual date in the overt acts. And if you look at the Cole case that counsel cited and the court was reading while on the bench, that's exactly what the Cole case was getting at, which is that the problem with the indictment in the Cole case was that it did not list the individual dates that the state alleged, I believe 38 different acts. If I'm not mistaken, 38. They didn't list the individual dates, and that was problematic. Here, this indictment does. This indictment lists 225 different individual dates. On its face, it is perfectly fine. As Ms. Dixon indicated, and there's a statement from a co-defendant that indicates in this case when the conspiracy started. And that is where it starts, is that there is, if you will, a promotional video, for lack of a better way of calling it, where a co-defendant talked
Your
about when
Honor,
it
do I
started.
have to continue to object to proffering? Because we're now getting more proffering. There's a co-defendant statement. That's a proffer.
He's now contemporaneously objecting to your proffer, Mr.
It's a little late, Ms.
Fowler.
Dixon's though. And I'm just repeating what Ms. Dixon said. And so that's all we have to do according to the Cole case. Now, going to the court's question a moment ago, I wanted to address the court's question. You brought up a certain date, I believe it was May or March, and if I could, just ask the court to repeat the question, if I could.
The dates alleged in count one, the date range is May 25th, 2020 is the first date. The date of the first overt act listed in part two of count one is on or about July 5th, 2020.
Yes. And the reason,
And there are no dates prior to that. It looks like if you go through all these, they are in date order all the way through overt act to something.
yes, that was the planning for that attack in July. That's what that was, but it alleges dates. It alleges specific dates in accordance with what the Cole case requires. And so the defendant's demurrer should be denied.
Okay.
Thank you.
All right. If y'all are waiting on rulings from the bench, you're not going to get them. So,
Your Honor, I have nothing further on that issue. I will note that there are other issues raised in my demurrer that parallel issues by other counsel, and I believe are better argued by other counsel.
okay. So who you going to the bullpen for?
I ask for the court to hear from Mr. Don Samuel.
Your Honor, before we go into that, may I address one question of clarification as we get to trial, based on the state's argument? It's my
If we
understanding-
get to trial.
If we get to trial, it sounds like what the court is hearing from the state is that they will prove that my client was in a conspiracy starting May 25th, 2020.
Hold on just a second. Mr. Samuel, you knew you were going to be speaking and you sat all the way down at the end. Y'all let him sit down there. Go ahead.
I just want to clarify what the being said from the state. It sounds like they're going to prove at trial this element that they're stating is that my client, each of our clients, is going to be in this conspiracy starting May 25th, 2020. I just
No,
want
what
to
it sounds like is they're saying the conspiracy started in May of 2020, and at some point or another, these 61 folks came and went through this conspiracy. Not everybody joins a conspiracy at the same time.
I guess the
Some
language.
people join later, some people leave later, but that's the way I understand conspiracy.
And the language as count 1 is written is that they charge Spencer Liberto with the offense of racketeering that said accused individually and as a person concerned in the commission of a crime and together with unindicted co-conspirators in the state of Georgia and county of Fulton on or between May 25th, 2020 and August 25th, 2023. And then they go on with the rest of the indictment of what he did. But the language of that says that's what Spencer Liberto did. Now, I'm not concerned necessarily with what the rest of these individuals did. I'm concerned with what Spencer did.
All right, hey, Mr. Kaczynski, Mr. Kazicki, may you interrupt? That I'm going to stop your interruption right
Okay.
there.
Housekeeping question.
Go ahead.
The court's made clear that for pleadings, we have to individualize our demurrers, our motions. We can't just adopt. This is the first time in the case, I think, where we have an objection sort of procedurally that a defendant has lodged. Do you want the other 3 who are here adopting that contemporaneously?
So I have to have listen to all 4 of you say I want in on that one.
And my recommendation is that should be
Yes.
the practice.
Yes. Unless otherwise stated, the 3 others will be joining in the objection. Unless you say, hey, Judge, I'm not in on that objection.
So it's an opt-out.
It's an opt-out.
Okay,
Yes.
understood. Thank you.
All right. Come on up, Mr. Samuel.
And just like we discussed, Your Honor, if we could, before Mr. Samuel begins, because Mr. Samuel does not represent one of these defendants, we could just put it on the record. The defendants have no objections, Mr. Samuel arguing this for the purposes of later appellate.
Fair enough. I think Mr. Hetzel actually, not only does he not object, he actually invited Mr. Samuel to testify on his client's behalf. So any objection, Mr. Hetzel?
Not for me, Your Honor.
Okay. Any objection from any of the other counsel?
I'm not opting out, Judge.
There you go.
No objection, Your Honor.
There you go.
Judge, is another housekeeping matter just before we get started with Mr. Samuel.
I did not think my house was that dirty.
Mine is, I mean, after preparing for this motions week, we won't talk about my house. So Judge, one request that the state would have is when we talked about our scheduling conference, my understanding it was that we would handle, that each of them would argue. So Mr. Carroll, the attorneys for Carroll, Papali, and Marsicano, and Liberto, whoever, would argue their motions to count, demurrers to count 1. And my request is if we could go ahead and let everybody argue what they're going to argue on that issue where they filed it, and then I would respond all at one time instead of just my request, instead of responding to each, because it's going to get redundant, if that makes sense to me, for me. Just a request.
Oh, it's going to be ugly.
I agree.
So, Mr. Samuel,
You want me to respond to that or just make my?
just,
All right, Your Honor.
my response is, please proceed, Mr. Samuel.
Your Honor, I represent Marlon Counts, Adele McLean, and Savannah Patterson, the members of the Atlanta Solidarity Fund, who were indicted being co-conspirators in this case. There are many issues raised in our demur. I'm sure you read the motion, the original motion, and the one that I filed again in accordance with your request on May 30th of this year. There are scores of issues. Maybe I could group them together in certain ways. Many of them deal with my clients and not necessarily with one of the first 4 in the first group. So it's a little confusing, but I am going to address all the issues in my demur. I don't think it makes sense, as you did with the prior argument, to take one issue at a time and have a response. But if that's what the court prefers, I'll break it down into different issues and you. can
No,
get
no,
response.
just Mr. Hetzel sat down after the date range and he wanted to argue date range first. I'm here for you all.
Okay, well, I will, if you want a response from the prosecution at any point during my argument, then that's fine. Otherwise, I'm gonna proceed from one argument to the next. Some of my arguments, or blend into both general demurrer and special demurrer, dealing with specific overt acts, specific aspects of the indictment that we consider to be right for a special demurrer. But I'm going to discuss all the demurrer issues in this initial presentation. I would point out that the prosecution, since we originally filed our demurrers close to 2 years ago, has never filed a response to our demurrers. They haven't filed a response when we initially filed the demurrers. They didn't file a response in anticipation of the oral argument before Judge Adams. They didn't brief the issue after the oral argument with Judge Adams. They haven't filed a response in anticipation of this argument today. So the only thing I know about the prosecution's response is the oral argument they made when we argued this before Judge Adams. I don't know if the issues, if their response is the same today. So I'm a little bit at a loss to anticipate what their arguments are. I can't preempt what their responses are, but I will reserve time to reply to what I may be hearing for the first time when they finally reveal what their explanation is for some of the defects in the indictment. And of course, I'll respond to any questions you had. We have broken down the demurrer issues into several categories, as I said. One deals with the problem. I'm only in the RICO count, by the way. We were originally indicted on several money laundering counts.
Null prost.
They were not prost because we filed a demurrer because they were so defective that I don't think even the prosecution contended they could go forward with those counts. They've been null prost, they weren't re-indicted. So we're just dealing with the RICO conspiracy here. My clients, as you know from reading the indictments, out of the 225 overt acts are listed in 80, 90 of them, maybe even more than that. But they do fit into general categories. There's a category I refer to as the seems no blog category of overt acts. There's this allegation, and I'm going to talk about this in greater specificity, but I'm just kind of giving you the table of contents at this point. There's this allegation that our three clients, in addition to unknown co-conspirators, all authored, calls to action, so to speak. We have seen no evidence of that in the discovery. Now, I'm not going to sit here and argue the insufficiency of the evidence, but it would have been nice had the indictment alleged some fact, any fact, that sufficiently alleged that the three members of the Solidarity Fund somehow had something to do with authoring documents that were, again, I'm going to refer to them as calls to action or suggestions that criminal conduct should occur. There's nothing in the discovery to verify that. And it also alleges in those counts that there were unindicted co-conspirators who participated. I don't know how many people in each one of those overt acts, the seems no blogs overt acts. I don't know how many people are alleged to have supposedly authored these documents or somehow responsible for what showed up in a magazine or in a zine.
See no blogs?
Your Honor, if you take a look at the indictment, just the very first series of overt acts, look at just overt act 6, for example. That's the first one. 5, 6, 7, 8, 9.
Got it. The URL. Gotcha.
Yeah. And just so you know, and I'm not sure it's necessarily relevant to a demurrer, we've even sat down with Mr. Fowler a year and a half ago and said, where is the evidence that either Mr. Counts or Ms. McLean or Ms. Patterson authored these, submitted them? What does it mean to say that they're co-conspirators along with unindicted, unknown co-conspirators who authored, these blog posts? And we were given essentially nothing. We were shown one document where the two names appeared on the same document. Atlanta Solidarity Fund and the Scenes blog appeared in one document together. There's no other evidence we've been shown Again, I'm not sitting here arguing that they got to prove their case in the indictment, but they have to allege the facts, which put us on sufficient notice so we can defend the case. That's the essence of a special demurrer. Allege sufficient facts so that the defense can prepare for trial. And they've alleged in the whatever you want to call them, scenes no block, overt acts, dozens of them. We're having to deal with trying to figure out who are unindicted, unknown co-conspirators. I assume they are not able to name them either, but at least by category. Where are these people located? What role did they play? What role did the three defendants who were listed in these overt acts? Over and over and over again. Three people plus all the unindicted co-conspirators, all supposedly committed every one of these 30, 40 overt acts, all dealing with the scenes blog allegations. I'm going to talk about those allegations more when I discuss some of the First Amendment problems here. So there are also numerous overt acts where they say there are known co-conspirators, but don't identify them. They've given us no information, zero information about who the known unindicted co-conspirators are. Take a look at the overt acts beginning at 63 through somewhere in the mid-70s. You know, maybe not quite a dozen, but almost a dozen overt acts where they said the defendants, again, always putting them as a group, they rarely, sometimes, but rarely even try to distinguish between Mr. Kaus, Ms. McLean, and Ms. Patterson. But they say they engaged in various criminal acts with known unindicted co-conspirators, but never provide us information about who they are. That's a special demurrer issue. There are, out of the 224, 225 overt acts, it is impossible to figure out what are the actual predicate racketeering acts that are the object of the conspiracy versus overt acts which are perfectly innocent conduct. There's a clear distinction in the law between what is a racketeering act, predicate act, has to be one of the codified crimes that satisfies the requirement in the RICO statute for to be a racketeering act, and an overt act, which could be perfectly innocent conduct in any conspiracy. If you and I decide we're going to go rob a bank, the object of the conspiracy is bank robbery. It's easy to identify, bank robbery. Give the elements of the offense, you know, an FDIC insured bank, and et cetera, et cetera. An overt act might be that you and I had a phone call. That's not a crime that we had a phone call, or we drove to a store and purchased a gun legally. That would be an overt act, as opposed to the racketeering act, which is the actual bank robbery stuff. The overt acts in this case don't differentiate between the two. And not a single overt act, not one, in this entire indictment, 224 overt acts, not one goes through the elements of any crime. So they really all are just overt acts, and there's never an identification of a predicate act in which they have alleged the essential elements of the offense. And we've cited to you the Heath case and the Sanders case. We put them in various places in our brief in which the court have said whenever there is a compound crime, and RICO is the essence of a compound crime, you have to set forth the elements of the underlying predicate offense. Not once in this indictment. Substantive crimes that I'm not involved in obviously go through the elements of the offense. But not one time in this indictment do they say that Mr. Kaus, Ms. McLean, Ms. Patterson, you know, committed the following or conspired to or did in fact commit any of the following crimes or conspired to commit any of the following crimes, and then list the elements so we can know that we're talking about there's the conspiracy the RICO allegation supposedly focuses on. They conspired to commit, you know, the use of a Molotov cocktail to assault a police officer and go through the elements of the crime. Not once in this indictment does the indictment satisfy the Heath and Sanders rule that you have to set forth the underlying predicate offense with specificity, both factually, and Sanders in particular does that, both factually and the elements of the offense. So we have problems identifying unindicted co-conspirators. We have problems with somehow throwing in co-conspirators. We have no idea whether they're going to claim that we were simply a party to a crime to some unindicted co-conspirator who committed this offense. And you're just kind of responsible on a kind of a Pinkerton theory, you know, Pinkerton, where every conspirator is responsible for what everybody else does. So we challenge the indictment for those reasons. The failure to differentiate racketeering acts from overt acts in the indictment.
Because merely reimbursing someone for money is an overt act, not predicate.
There's no doubt about it, it's an overt act.
Sure.
But you got to spell out in the indictment, and I'm going to come to this shortly, how did the overt act further the goals of the conspiracy? It's not just a question of proof at trial. When I gave you the example of a bank robbery, when you and I went to the store to buy a gun, yes, that's an overt act. But did we go to the store to buy the gun in order to go rob the bank? That's what's got to be in the indictment. You got to show how the overt act materially advances the cause or somehow is related. All this says is we bought food.
Is the word you're going for nexus?
Yeah, of course. Well, that's the essence of RICO, is the nexus between the racketeering acts and the enterprise. The nexus between the racketeering acts and the overall scheme here, which is completely missing. But I'm not even there yet to talk about the relationship. The enterprise itself is shockingly ill-defined, if you will. I don't mean to get so overwrought here, but you know that the enterprise is defined at various places in the indictment, most notably around pages 23, 24, 25. This is all in the indictment. This is not, you know, the introductory stuff. This is count one. They allege the enterprise beginning on page 24, actually in 25. At various parts, the enterprise is defined as a movement. Can you imagine that? That an enterprise is a movement? You know, the civil rights movement would be characterized as an enterprise, according to the Attorney General's office in this case. At other times, they describe it as a coalition. I don't even know what that means. I know the word coalition means, but a coalition they describe of environmentalists, plus anarchists, plus eco-terrorists. I know what Mr. Fowler's going to say, or Ms. Dixon's going to say, or, you know, representatives from the AG's office, they're going to say, well, an enterprise can be just association in fact, and that's true. It could be a police department. It could be a governor's office. It could be anything. But somehow it has to have some defined structure. That's the United States Supreme Court case, Justice Alito wrote the Boyle case in my brief. That the enterprise can't just be the acts themselves. You can't define the enterprise, which is the essence of RICO, racketeer, influence, corrupt organization. That's the O in RICO. There has to be an enterprise which is separate and apart from the acts that are committed. If you're just going to allege a bunch of crimes, you don't have RICO. And you have all kinds of venue problems at that point. You can't prove that the acts occurred in Fulton County or DeKalb County. You know, you even have statute of limitations problem. If they're all part of the enterprise, that's why you use RICO, is to try to get them all into one case. But the enterprise here is so ill-defined and so hard to grapple with. And I'll point out that my predecessor up here at the podium, his argument's fine. I think his argument's wonderful. I think another way to characterize his argument is if the enterprise throughout was to prevent Cop City or the training center, was to prevent building on the farm, how could they allege predicate acts that occurred before either of them existed? They couldn't have been predicate acts relating to the enterprise. That to me is the problem with the date ranges they've used with the earlier overt acts. If the enterprise was designed, the whole purpose of the enterprise, the existence of the enterprise was to stop the training center and to protect the forest. Those were the essence of what put these people into one group. And yet it occurred before any of those things happened. Then the enterprise has lost all structure. You know, Ms. Dixon says, well, we'll just prove it at trial. But they're not going to prove what they alleged, because what they alleged as the enterprise had nothing to do with Rayshard Brooks. That's the May and the shooting in Minneapolis, George Floyd.
Rayshard Brooks was here.
Rayshard Brooks was here, George Floyd was in Minnesota. But that's the date range they're picking on. They're saying those events is when the enterprise began. And yet they go throughout the rest of the cases, the enterprise is the forest, either the training center or the environmental problems. I just add that because of what the argument was before. To me, the date range is inconsistent with the enterprise that they've defined. That's the problem. And I raise it in our brief as a problem with the definition of an enterprise, that they are incapable of defining the enterprise with any meaningful structure or membership. Lord knows how many unindicted co-conspirators they're going to end up talking about at trial without ever identifying them, or how many known co-conspirators they're going to identify at trial, maybe for the first time, since they haven't identified them yet. I mean, there may be thousands of people who they're going to say are members of this enterprise. They may say, because they suggest it, any anarchist in the country is a member of this enterprise. California, New York, Boston, they mention all of that. It's all in their indictment, in their introductory sections about we're going to, commit crimes in New York and Boston and California, and we're going to go after this enterprise is larger than the Vietnam protest, as far as I can tell. As far as I'm concerned, if I was protesting the Vietnam War back in the 60s, I'd be part of the enterprise, because some of the people committed crimes during those protests. What are you going to do with the NAACP? There were crimes committed. There was trespassing that was committed. There was civil disobedience that was committed. And there were even some violent acts committed. And some of those people belonged to the NAACP. You're going to say that's an enterprise? And it was all part of one RICO case because some members of the enterprise or some members of the group engaged in criminal conduct. The United States Supreme Court says you can't do that. The NAACP versus Claiborne Hardware, which we've cited in our brief. You can join a group. You can be a member of an organization or a movement or a coalition and not be guilty of a crime, even if other members of the movement or coalition do commit crimes. And that's what they've done here. They've taken all these people and thrown them in an enterprise and said, here's your RICO. They're all racketeers. So that's, the argument that we make in our brief, in our demurrer, challenging the definition of an enterprise. It is too amorphous. It is indistinguishable from the acts, from the criminal acts that they claim that the enterprise members committed, and it sweeps in so many innocent people who were just members of a movement or members of a coalition, and then includes, as I said, how many hundreds or thousands of unindicted co-conspirators who were, quote, anarchists or defund the police individuals, or people who protested George Floyd, the BLM, or protested the Rayshard Brooks shooting. Now we know they're all part of it because they alleged it, that's when the enterprise began. The hundreds or thousands of people who protested, police brutality in this country. So that's our enterprise allegations. I don't even know where to begin with the 25 pages that count one starts with. I do a lot of practice in federal court. There's a lot of speaking indictments there. They alleged to have introductory language, which is, in my view, offensive, but clearly tied to the crime. Right? I mean, there'll be introductory language, in healthcare fraud cases that explain a little bit about the history of Medicare and how it works. And it doesn't look like a typical indictment, but it's clearly focused on the actual crime that is set forth in the ensuing counts of the indictment. I'm talking about what we call speaking indictments in federal court. And I don't know if the Attorney General's office in this case tried to learn from that. But I seriously, Judge, ask you to really carefully read pages 25 through 49 of this indictment.
The court has read the entire indictment.
Yeah, well, you want to read it again because it's shocking. It is absolutely shocking that any prosecutor in this country would think that belongs in an indictment. I am absolutely appalled that the Attorney General's office in this state believes that it's appropriate to present to a grand jury and to present to the jury in this case, to you, to the public, to the press, 25 pages that discuss, can I quote just a few excerpts?
It's your record, Mr. Samuel.
It's their indictment.
That I don't have to read to a jury.
They read it to the grand jury. The jury has to be told what the indictment is that the grand jury returned. They can't return an indictment or a verdict for something the grand jury didn't indict for. And the grand jury, I've never been in a trial where the jury doesn't get the indictment to deliberate in state court. But this indictment begins with talking about anarchist ideals. We're anarchists, I mean, they clearly blame my three clients as being anarchists. Anarchist ideals date back centuries. Well, that's a hell of a thing we're going to have to defend against. Is that going to be something that the jury is going to have to find beyond a reasonable doubt? Are they going to be told about the history of anarchism? Are they going to present evidence of that at trial? Violence is part of the anarchism in some anarchist beliefs. Anarchists often point to law enforcement as one of the chief violent actors in society. Violent anarchists often engage in violent activity towards law enforcement. This is totally ill-defined. We're not talking about our case. We're not talking about our case at all at this point of the indictment. But you want to know some other examples? Well, they provide them in the indictment. Examples include 2020 movement in Portland, Oregon, Seattle, Washington, the latter known as the Capitol Hill Autonomous Zone. That's in Washington. And of course, later there was the Autonomous Zone in Atlanta. This is all in the indictment. This is all what the grand jury was asked to sign their names to. And then it goes on to start quoting anonymous people, black-clad, masked people who gave speeches about defending the Atlanta forest. They put that in the indictment, as if that's relevant to anything that's going to happen at this trial. Are they going to just abandon the confrontation clause? Are they going to put in evidence of what masked people said outside the courtroom, never going to be cross-examined about what this movement should be doing? We need to kill more policemen. A known defender of the Atlanta forest was recorded complaining that there were not enough violent members in protests against the training center. That's in the first 25 pages of this indictment. Then we get compared to Mexican Zapatistas, Syrian revolutionaries. That's what we're being compared to. Kurdish revolutionaries in Afghanistan. What is this doing in an indictment in this country, in this county? We raised all these arguments to Judge Adams. With all due respect, not a word in the original order in this case said there was anything improper about that. As if we all need a pseudo history lesson from the Attorney General about, the background of my clients, their historical predecessors. This pseudo history that has no business in an indictment. And I don't know what you're going to do with it. You're just going to throw it out and say, we'll let the prosecution prosecute whatever they want in this case. We're going to throw out the first 25 pages because that's clearly inappropriate. It's full of hearsay and confrontation clause and, as I put in my brief, events that happened centuries ago. I would really like, if I can pose a request to you, that you ask them, what in the heck was that doing in this indictment? What were those 25 pages designed to do? Who was the audience for those 25 pages? It is, I think I've already said it was offensive, that you may be able to gather from my tone of voice. It is inexplicable to me why this indictment wasn't dismissed within weeks of it being returned with that kind of BS in it. We have devoted a substantial part of our demurrer to the First Amendment issues in this case. And they are, the indictment is just saturated with assaults on the First Amendment. It is throughout the indictment, from beginning to end, there are allegations of conduct which is clearly protected by the First Amendment, as if it's a crime. From the definition of the enterprise, you're an anarchist. Clearly First Amendment protected. That's like saying the enterprise in this case is full of people who belong to the NAACP. Can you imagine something like that in an indictment? They say that the enterprise in this case was comprised of people who are anarchists, who are involved in protecting the environment, people who are engaged in direct action. I did that. Did you do that? I do it on weekends now when I go out and do the No Kings marches. Is that an enterprise? Promoting anarchist ideas? Next thing you know, they're going to say it's a crime to promote democratic ideals or Republican ideals. As if that makes you part of an enterprise and violates everybody's First Amendment rights.
I'm a little more constrained than you are by the Judicial Code of Ethics, Mr. Samuel. I'm not out on weekends.
Yeah.
I said I'm a little more constrained than you are by the judicial canons of ethics. I don't go out on weekends.
Yeah. Well, I know I've seen members of my colleagues in the defense out there, and they wonder, I guess we're next, right? We're out there protesting, probably trespassing, not within the bounds of where the parade is supposed to be. The overt acts that even the scenes block, even the offensive scenes block, it's going to offend the jury if you read some of these. But the United States Supreme Court has said, unless it's an immediate incitement of riot, Brandenburg versus Ohio and the United States versus Scales and all the cases we read about in law school, unless you are inciting a riot, you are not guilty, even if you're calling to action, even if you're encouraging what would be described as criminal activity. It's protected unless it is an immediate incitement to riot. We've cited those cases to you. I keep telling you that because I don't want you to blame me for bringing up cases here that weren't in the brief.
Wasn't blaming Mr. Hetzel.
I-
Commenting.
Well, thank you, Your Honor.
We're on the same side here.
Couldn't tell by that.
You couldn't tell. Then we have the problem in the indictment, not just the First Amendment, which is part of the scenes blog problem, but the lack of any connection between, and we mentioned this earlier, the lack of any connection between these alleged overt acts and any criminal conduct in the indictment. Yeah, now Ms. Dixon may get up and say, well, we'll just have to prove it at trial. Well, these are demurrers. And the basis of these demurrers is you haven't given us the information to defend, number one. And number two, you haven't constrained what the jury can do. Because if you can say, well, you woke up in the morning, and that was an overt act, well, then they can prove anything at trial. They've got to prove what's alleged here, and that what's alleged here were overt acts that furthered the ends of the conspiracy. Buying food, dozens of overt acts. You reimburse someone who bought food with no allegation anywhere in this indictment what that had to do with anything. Where was the food eaten? Where was the food brought? Who, there's nothing. And don't let them stand up here, the AG's office, and say, well, we'll show you a trial. They're supposed to show it in the indictment. That's what an indictment does. It's the blueprint for trial. It tells you where the structures are, where the steel beams go. Well, this doesn't tell us anything. You paid for food. You paid for Deep May, which was, maybe you remember seeing some of that in the indictment. But what the heck is Deep May? It was a computer training class for teenagers and young adults. There were professors who came from a university, came down here and taught people how to do troubleshooting on a computer. What is that doing in this indictment? And don't let them tell you, because it's not in the indictment. Don't let them stand up here and tell you, oh, I'll tell you what's bad about that. It's XYZ. It's in the indictment if it's going to be XYZ. That's why we have indictments. That's why we have all the rules of discovery. But even that's not enough. If it's not in the indictment, then how's the jury going to know whether they're convicting them of something with which they are charged? The relationship between the racketeering acts and the enterprise is exactly what Kimbrough's all about. I think you mentioned Kimbrough when I stood up here. And that's kind of the essence of the demurrer problem. But that's just one problem. That just deals with the relationship between the crimes and the enterprise. And Kimbrough's clearly the lead case on that point. The First Amendment, there's just no shortage of cases, including, again, in our brief, the recent Ninth Circuit case that even found the federal statute defining riot act unconstitutional because it didn't clearly and directly focus the incitement and the crime. It wasn't a close enough link. And all these scenes blog allegations in the indictment are defective for that reason. I mentioned before this whole problem of all these overt acts that just have who knows how many different members, unidentified, some known, some unknown. And I have no idea. I've been working on this case for 2 years. I've been representing the clients for time before that. You know that from the filter team problems. To say that Couch, Tash, McLean, and a bunch of unindicted co-conspirators all did X. How am I supposed to prepare for that? All three of them did it? One of them did it? The unindicted people did it? But you're all being held responsible. You're all being held responsible because you're parties to the crime without any definition of who did what. Your Honor, the indictment in this case is, with all due respect to my colleagues, It is a disgrace. It really is. It's a disgrace. It's an assault on the First Amendment. It's an assault on the right of people to protest. It is grouping all these people together and claiming that they're all a bunch of anarchists and criminals, that they should go to prison for the racketeering act of 20 years. Some of these people, were down here for one day. They went out, they protested, and they're now being labeled racketeers. My clients never are alleged to have gone out to the forest. Not once. They are firm believers in the First Amendment. They exercise their rights under the First Amendment. They have a right to do that. You should be protecting it. The AG's office should be protecting it. And if necessary, we will be asking the jury to protect it. But you should put a stop to this, with all due respect, Your Honor. You should say, you want to indict someone for throwing a Molotov cocktail, indict them for throwing a Molotov cocktail, and don't indict 61 people. You want to indict someone for threatening a construction company, indict him for that, if you got venue. And I ask you to grant the general demurrer, grant the special demurrer, and tell the Attorney General this is not how we conduct criminal business in this state.
State?
Because I think I'm gonna start, do my best to answer what was alleged and argued, and yet still stick somewhat to an organized presentation of the argument too. To do that, I'm gonna start with just a key point, excuse me. First, one of the things that is important is there was an argument about the introduction as if it was separate from count one. I would just like to point out for the record that the introduction to this, which talks about, defines, and articulates facts pertaining to the enterprise, is actually contained in count one. It is part of count one. So that introduction in the body of the indictment is part of count one. That's just a housekeeping thing. However, there's a
I
couple
think
of.
that was part of his complaint.
Okay,
I think he agrees with you,
agreed.
Mr. Samuel.
Yes, exactly. That's the problem. If
Yeah.
it wasn't part of count one, who would care?
Well, and Judge, so I'll get to that. And there's a separate motion, and I think Mr. Fowler will address, there's a motion specifically about the political rhetoric in the
There are
complaint.
many motions
Yes,
regarding the
agreed.
political rhetoric.
And Mr. Fowler will be predominantly addressing that. I'll hit on it a little bit. But there's a lot of issues to cover. I'm going to try to hit them all. And Your Honor, the indictment in this case charges the necessary elements of conspiracy to commit RICO. And I want to and I know this after in response, it seems kind of anticlimactic to get up and just talk to you about the elements, but that is what we're here to establish, is whether or not the state actually alleged sufficiently the elements of the offense. And I won't go through all of exactly what is said because the court has read and studied the indictment. But count one does specifically set out that the individuals charged acted together, individually and as parties to a crime, or as persons concerned with commission of the crime. That is in there. They acted together with unindicted co-conspirators, together and with unindicted co-conspirators. It alleges the date range. It alleges that they did so while associated with an enterprise. They unlawfully conspired and endeavored. And it alleges the enterprise as well as the pattern of racketeering. And then, Judge, and there's a lot in this indictment, which the state is very well of, but part one defines the enterprise, and that's where they started a lot of complaints about the enterprise. And in part one, it gives the overarching intent of the enterprise. It gives how the racketeering activities are connected. It
It's
talks.
a bad political science paper. I never thought a political science degree would help me. It clearly is the first time since graduating, other than going to law school. There's problems with this.
And Judge, I would get back to the, or what might be surplusage or unnecessary in there. But the reality of it is that as far as whether we alleged, because one of the things they are saying is that.
How is Aleppo,
I'm sorry?
how is Aleppo going to go in front of a jury?
I'm sorry.
How is Aleppo going to go in front of a jury in this case?
Okay, Mr. Fowler said he'll handle that.
Okay.
All right, Judge. So to address everything, because we need to establish the record, there are two key things that are in paragraphs A and B, two instrumental and key things. Paragraph A, the indictment alleges that each individual charged in this indictment knowingly joined the conspiracy in an attempt to prevent the training center from being built. It also alleges that the conspiracy contained a common purpose to commit two or more acts of racketeering. And then in count B, Judge, the indictment goes on as in describing the enterprise.
In paragraph B?
Yes, paragraph B in the introduction, Judge. It goes on to articulate and allege that the defend the Atlanta force, which is the defined enterprise, is a self-identified coalition and enterprise. And then it goes on. And what is key, though, because we do have to allege the nexus, is that paragraph B to the introductions affirmatively alleges that defend the Atlanta forest, this enterprise, conducts direct action designed to prevent the construction of the Atlanta Public Safety Training Center and Shadowbox Studios and promote anarchist ideas. That the self-proclaimed direct action has included vandalizing private property, arson, destruction of government property, attacks on utility workers, attacks on law enforcement, attacks on private citizens, and gun violence. It also alleges that the purpose of these actions is to prevent the construction of the Atlanta Public Safety Training Center and a movie studio, all while promoting the virulent anarchist ideals. So in the intro paragraph to the indictment, it sets out what the enterprise is, who this group is. It gives a lot of other detail, which I'll get to, but it also establishes an allegation regarding a nexus between their activity and their end goal, or the motives and the end goal of the participants in the conspiracy or the enterprise, excuse me. And so then in count two, I'm just gonna, what do we have to allege? Count two says the defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described below. The indictment then sets out 225 overt acts, some of which are predicate acts. And I'm going to talk, unfortunately, extensively about which of those are and what the law is there. But those 225 overt acts contain allegations of a multitude of racketeering activity acts. And they include influencing witnesses, assault, aggravated assault with firearms, domestic terrorism, arson, and acts and threats involving arson and felony obstruction. And like I said, I'll address some of where that is in a moment. But as the court knows, and as the defendants have argued in a lot of their motions, the test for general demurrer is, can a defendant admit all of the facts in the count, in each and every count, the entirety of the indictment, and still remain innocent? And I'm going to come back to that because Mr. Samuel didn't really address it, and I believe others will. But that is what the test is. And the state asserts that Judge, and we can bullet out, they absolutely, a general demurrer is not going to get them there, because if they admit each and every allegation in this indictment, they are definitely going to be guilty of multiple offenses, including RICO. Now, I'm going to go ahead, Judge. Let me see, all right, whether the enterprise was sufficiently alleged. There's a multitude of arguments from different defendants about the structure. Mr. Samuel did mention it. And I'm going to read for the court. All right. Yes. Thompson v. State, 211, Georgia App, 887 at 890. It's a 1994 case, Judge. That is just one of the things it says, is that appellants contend that they did not have requisite knowledge of the criminal element of enterprise to sustain their RICO convictions. But none of the provisions of the RICO Act, however, requires that each and every defendant in an enterprise have full knowledge of all facts or all facets and elements of the enterprise, and that all members or actors, and all of its members or actors. An enterprise is not a criminal act itself. It is a description of the entities involved in the RICO violations and may include activities involved in illicit as well as licit activities. It is the racketeering activity, the pattern of racketeering, the predicate acts, which is illegal, not the enterprise itself. Although the enterprise may be proved by the same evidence which proves a pattern of racketeering activity. And Judge, in addition, and we'll talk about the structure in a minute, but while some structure is required, this indictment more than does that. And in paragraph 3 of the indictment, as far as how we allege this enterprise, I mean, this indictment talks about how they recruit, how they're trained, what the connection to each other is, what their motive is, what their end goal is, what different, it alleges different.
Paragraph 3.
Excuse me, I'm sorry, I'm just going. Paragraph 3 of the introduction explains how the propaganda, recruiting, providing finance, it talks about.
Just give me a page number, because paragraph 3, count 1 has A, B, C.
Mhm.
Part 1.
Oh,
You have part 1, then you have A, B, C, D, F, then you have part 2.
gotcha.
So
2 seconds, Judge. I did say paragraph 3, I apologize.
part 2 is the overt act.
I think, what page is that? I think it's the bottom page 28, Judge. And let me just generally characterize it if I can. In the introduction, which the court has studied, the indictment sets out the propaganda, the recruiting. It sets out how finances are provided, who is provided, or what entities are providing, how they shift money and pay money and what they're paying it for. It sets out how the enterprise provides support, emotional, personal, preparation for arrest. It alleges that it provides premeditation, or the enterprise premeditates committing crimes, and that all of those things are part of this enterprise. On page 33, paragraph, anyway, it specifically talks about, in the introduction, how this enterprise is designed and does promote and agree to promote conduct
On page 27, a local
Yes.
anarchist supporting the Stop Cop City movement
Yes.
recently wrote, any idea who that is? Any idea how these people are supposed to know who that is? Any idea? As noted by the anarchist above.
Judge, I think it's, from what I understand, it's in the discovery, right? Is it a part of scenes logs, or is it one of the? It's in the discovery.
The indictment.
Yes.
When a court considers whether an indictment is sufficient to withstand a special demurrer, it is useful to remember that a purpose of the indictment, not the discovery,
Yes.
is to allow a defendant to prepare her defense intelligently. So looking at the indictment, their argument is you can't fix an indictment with 10 terabytes of discovery.
And, and I understand.
They should be able to
that.
look at this 109-page document and go,
Yes.
here's what we got coming at us.
Yes.
And unnamed quotes. That's problematic.
And as I.
It's in the discovery is not a good answer, is what I'm telling you.
So, and Judge, let me just go ahead and skip to this issue. So the indictment contains things, and I think in the last trial, in Isla King's trial, when we had it.
We have not had an Isla King trial.
Okay, in the previous.
We have not had a trial in this case.
Previously, when we prepared for trial in front of a different judge. We, with the defense, the state and the defense got together and they agreed that certain items would be redacted and that or certain statements, certain portions of it would be redacted. And that is, again, what the state's position is.
That's because that defendant announced ready for trial by filing a speedy. These folks have not announced ready.
And the state's position. And again, Mr. Fowler is going to, do you want him to go ahead and do it instead of coming back around to it because he is prepared to?
I'm here for the
articulate
duration. Y'all do it in whatever order you want to.
Do you want to go ahead and address the rhetoric issue? Because I think there's a separate motion, but let's go ahead and address that.
Thank you, Judge, and I apologize for kind of the I think we call it whack-a-mole way of standing up and sitting down. I think that's how the game works, but the way that the motions were filed. So I'll go ahead and get right to it. And that is that one of the things.
Sorry, I just want to keep up. What motion are we on now?
I believe it's number 17 on your list.
17?
Yes.
No.
Well, it's
No.
the same motion, and this is the issue that we had. It's the same motion that they just argued, but it overlaps with 17 is what I'm telling counsel. And this was our difficulty in getting prepared for this, is that there are separate motions that are filed by certain defendants that also contain the same argument in the first motion that Mr. Samuel just argued. So that's when I say 17, it's a separate motion that was filed by Mr. Carroll that is on the list, that is also included in the argument that Mr. Samuel makes. So when I tell him 17, that's.
Yes, Mr. Schwartz?
No, we're having a cooperate here. Let's see how it goes.
Look, there's no question that there's a ton of overlap. And I understand that's why the previous judge may have done things the way she did. That's the way she's used to working, and that's fine for her. And I made you guys parse it out separately. That doesn't stop the fact that there is overlap between y'all's motions. So, all the housekeeping in the world isn't going to stop this from being a little bit sloppy and piecemeal. Go ahead.
Thank you, Judge. So let me start with this, which is that one of the things that was raised was the complaint that the scenes blog did not adequately allege in the indictment that they are able to attack that. Now, let me give the court a little bit of background because the court kind of made a face when they started talking about the scenes blog or scenes.blogs.com, whatever it is. And counsel is right that the scenes blog is outrageous because what it does as part of this conspiracy is to get online, post online, hey, we just burned this stuff to the ground. We're going to do it again. And if you don't stop building the training center, we're going to keep building your stuff down.
And correct me if I'm wrong, Mr. Samuel, I think his argument was there's nothing in the indictment tying his folks to it. We got the metadata from their whatever. We got something. It's just these folks, along with people we don't know or unindicted co-conspirators that are unknown, along with people we don't know. So
Did publish.
basically, keyboard warriors.
To publish, yeah, not just keyboard warriors. I mean, keyboard warriors get up and argue a purpose. This went further than that. This went further than that. This went much further than that. This was a purpose, this was intended to intimidate witnesses. And that's the allegation, because if you look at it, we give them the date. We give them the internet website. We give them the contents of the post. We give them the intent of the post, and we say who did it and that they published it. That is a lot of information. That is a lot of information to be part of an allegation. We didn't just say that they believed this. We didn't just say that they did. We give them date. We give them date. We give them contents. We give them purpose and intent. We give them motive, and we allege who did it. That is plenty to do it. And in fact, we actually allege, if you take a look at it, we allege the elements of witness intimidation in that overt act right there, which would be sufficient as an independent crime in and of itself. But this is merely an overt act, and overt acts don't require that there are crimes. So not only did we sufficiently allege it, but we more than sufficiently alleged it. And I know that it appears that Mr. Samuel had his caffeine this morning when he got up here, but the reality is that we did more than we needed to do when it comes to the scenes block sort of stuff. The claim that it's First Amendment protected, and there are First Amendment protections, and we're starting to get into a little bit of a different argument over breadth, which I will address differently, which I'll address a different argument, I think, unless I need to go ahead and do it now. But obviously, you can't just say anything that you want. You can't. There are limitations to the First Amendment when it comes to what you say and and the things that you do. But I will address over breadth later on. Coming back to this, you don't have to allege how it furthered the objective. That's their primary. You don't have, or how it furthered the nexus. You don't have to allege that. You simply have to allege that it is an overt act in furtherance of the conspiracy. That's all you have to allege. That is the only language that is required. And it is listed in a separate sentence after all 225 overt.
You got a cite for that?
But it's back. I will get it to the court.
Go get it. I want it now. No. If it's at your table, I want it.
What is the principle that you're needing a cite for?
Yeah, that you don't have to.
Conspiracy. You don't need a nexus between that.
The overt act or the
Yes.
predicate act?
As for the political rhetoric, what the court called, I think, a bad political science paper, a bad political science paper we got from the defendants themselves in the documents that we located in search warrants, in the forest and documents that we found. This is where we get it. And it's important to understand that this is how we get here in this case. And I know it reads unlike anything we've seen before. It's certainly something that I've never seen before. And let me give the court a different example of indictments that are fine when you do something like this. And I know we've talked about gang cases before. This happens in gang indictments too. How do gangs get where they are today, leading to the violence or the fraud that they do, kind of depending on the gang. You can do that. You can make that part of it. And I'll cite to the court, believe it's, and this is a second, I'm sorry, there's a Second Circuit case, United States versus Scarpa, where the defendants unsuccessfully moved to strike 16 paragraphs captioned Introduction to All Counts, which was devoted to an overview and history of the Genovese organized crime family, which was a racketeering prosecution, and how it began and how it got where it got, and the beliefs of the organized crime family and how all of those tied together. In addition to that, and even if the court doesn't think that that language should be in the indictment, what's interesting is that counsel filed a demurrer, but I point the court to a,
You gonna give me a cite on that one?
I'm sorry, if I
It's
did
a
not
Second Circuit
apologize.
case.
Yes, it's 913 F second 993, page 1013. I would also, and I would also give the courts United States versus Bellomo, Bellomo, 263 F sup second 561. And so you don't have to scroll forever. It's pages 584 through 585. Now, I know that counsel filed a demurrer to the indictment, but demurrers are not the proper vehicle for this. The proper vehicle and the remedy that counsel needs to ask for, and the proper remedy is if there is surplusage in the first part, this court does not think needs to go to the jury, in which case it would be surplusage. The state doesn't have to prove it, would be to ask for it to be redacted. And there's a case, it's just an opinion out of the Superior Court of Cobb County, so it's not persuasive on this court, but it's well written, I will say that.
It's not persuasive, yeah, Cobb County.
It's not binding on this court. How's that? Maybe that's the better terminology. I don't know which judge wrote that, but I hope they're not listening right now. And it is 215 Georgia Super Lexus 7038. And it's a finding in a motion for new trial that trial counsel was not ineffective for a failure to file a non-timely demurrer. And they don't really talk about the timeliness of it. But it does say in such a situations, a motion to strike the surplusage, which was never filed, rather than a dismissal of the entire count is the appropriate remedy. And it cites to United States versus Clinton. That's 285 F second 378. It also says that even if an indictment is lengthy and needlessly verbose, does not mandate that it need to be dismissed. Instead, the defendant's proper recourse is to file a motion to strike surplusage from the indictment. That's United States versus Watson, 2008, U.S. District, Lexus 59323. There are Georgia cases on that as well, where the cases have found that refusing to strike surplusage in an indictment is harmless. That's, I think it's Malov, M-A-L-L-O-V. I don't think it cut it off in Malloy. I think it's Malov, however you say it, versus the state. 293, Georgia 350. Supreme Court dealt with an indictment charging Medicare fraud, which included language beyond the statutory language. The court noted that surplusage does not vitiate an otherwise valid indictment. And that cites to State versus Barnett, 268, Georgia Appeals 900. I would note that in the Barnett case, the court ordered that the term family violence be redacted from the indictment in the introduction. It doesn't really get into how it wasn't, but somehow it made it to the jury. And the court later found that that wasn't an issue because it wasn't something that the state had to prove. And so this allegation that the jury read it and therefore convicted because they were somehow poisoned by that or tainted by that, the court dismissed that and said, no, it has to do with the evidence that goes before the court. Finally, there's another case that stands for it. I'll go ahead and give it to the court. It's Eidson versus the state, E-I-D-S-O-N, 262, Georgia Appeals 664. That's a 2003 case. So I give the court all of that to let the court know that even if there is any a part of that, it shouldn't be in there. The proper remedy is a redaction, like Ms. Dixon was getting at when we were preparing for the Isla King in front of Judge Adams, that the proper remedy is to redact it. Now, we never reached that for a number of reasons, but that's a totally separate issue we're not addressing today. That would be the proper way. I would suggest to the court that it's not, that these are things that these defendants had in documentation, things that they wrote, things that they said, all of that sort of stuff. And this history lesson, while I agree with you, it's an unusual history lesson, comes from these defendants themselves. It explains how we got here, and the motive for the reason that they do things. And we talk about that a little bit in the indictment. When we talk about the nexus while promoting anarchist ideals, and we talk about that as part of the nexus and part of the violence and the property damage, the gun violence, the arsons, the going after civilians who are just doing their jobs, all of that sort of stuff is part and parcel of this case. And for those reasons, we believe it should go out with the jury. If it doesn't, the proper remedy is merely redaction. And I believe that I will now turn it back over to my colleague, if I may.
Okay.
So that's the state's response regarding the alleged rhetoric in the introductory paragraph, Judge. The other things that the state has argued, or the defense has argued, particularly Mr. Samuels, is that the indictment is violative of the First Amendment, and in the speech and the assembly and the right to associate. And again, we'll have other motions, so I don't want to hammer the point. It was a passing reference for in multiple of these, but first and foremost, the reality of it is read the indictment, because it is this argument that they're making that the state, through charging this, basically said if you protest, you're a racketeer, is essentially ignoring the contents of the indictment. The indictment makes it very, very clear. And quite frankly, my co-counsel and I have talked about this. We unabashedly and absolutely unequivocally agree that who you associate with, what you believe, in the quiet of your own home, particularly what you may say to somebody, that you can believe completely different. You can believe unpopular, you can believe popular. None of that, all of that, I should say, is protected 1,000%. But what you can't do is, because of those beliefs or for any other reason or some other belief, you absolutely cannot agree and join in with a group of individuals who are associated in their conduct and in the way they conduct themselves, in their beliefs, whatever it may be. If they are associated in their, in fact, in the way they are conducting their affairs, you cannot agree and become a part of this enterprise, therefore, and agree that you're going to, or your co-conspirators or somebody else in the enterprise is going to go out and commit certain crimes or acts or threats involving certain crimes. And we'll get to that in a minute. So the reality of it is, people can get up and wave their arms and yell and scream about the First Amendment and become insulted and indignant. But this indictment in no way is talking about this. The indictment is charging people not with their beliefs. Their beliefs are their motive, their evidence of their motive. What they say is evidence of their intent and their motive. Absolutely. The state will say, yes, that's true. That's established law in this state and elsewhere, that speech can be used as evidence of intent and motive. But the reality of it is that while you can associate with who you want, you can protest. You can peaceably assemble, you can protest, you can do all of those things. What you can't do, shoot a police officer, hold a gun on a guy's head who simply showed up. He's just a metal scrapper, and it's in the indictment. I'm not proffering. It is in the indictment. You can't hold a gun to a guy's head because he happened upon you and hold a gun to his head with a deadly weapon, by the way. So, ag assault. You can't shoot fireworks at EMT and firefighters. You can't burn down or try to burn down buildings. You can't burn up the police cars of the Atlanta Police Department. You can't destroy construction equipment. You can't threaten and terrorize people. You can't do those things. And if you do those things, and you then also agree with others and take the steps and commit the other elements of conspiracy to commit RICO, yes, you have committed a RICO. And it's that basic. This is not about what they believe. This is about what they did, and what they did, not to the police, just to the police, not just to firefighters, not just to EMTs, not just to law-abiding citizens who work and have built companies and had contracts to have something to do with this, or in some way to build or construct or to clean or whatever, the police public safety training center. It's a mouthful. It is not. In the end, it is about the criminal actions that they took, that they agreed to took, that they knowingly understood that this group and this enterprise was going to take. It is about that, and that is what the indictment charges. Now, does the indictment charge a pattern of racketeering activity? And I need my glasses. Excuse me, Judge, I apologize. And bear with me, Judge, if you will, please. This particular issue within this case is a little bit convoluted and complex, as is, seems like everything to do with RICO charges. But I'm going to start, Judge, with just pointing out, and some of these cases have been cited by the defense in their motions, but Borders v. State, 270 GA, Georgia, 804, 1999. The court said, the Supreme Court of Georgia said, an indictment apprises the defendant that he may be convicted of the crime named in the indictment, of a crime included as a matter of law in the crime named, and of a crime established by the facts alleged in the indictment regarding how the crime named was committed. And an indictment is void if it fails to establish or charge a necessary element. Second premise, Judge, is while a defendant may desire greater detail, and this is and specifically English v. State v. English, excuse me, 276 Georgia 343 at 346. Specifically, I know that they want more detail. They want everything and anything that we're going to argue, allege. Our thought process is how we plan on and strategizing for this trial. Yes, they want that. But in English, the Supreme Court of Georgia said it is not required that the defendant get every detail of the crime. In additional, in State v. Wyatt, 295 Georgia 257 at 263. And here's, I know this goes back to what you mentioned already. However, Georgia Supreme Court says instead, it's not necessary that the indictment contain everything they need to know. It's not. Instead, additional details the additional detail desired may be supplemented by pretrial discovery he or she receives and any investigation their counsel conducts. And so it is interpreted and it is anticipated for the obvious reason. I don't need to keep reiterating that. It's blatant. We don't have to allege every single fact that they may want to know in the indictment.
Let me stop you right
Yes.
there, Ms. Dixon.
Yes,
Two things.
yes,
One, I'm going to cite from Kimbrough, which cites from English.
yes.
To be clear, we do not mean to suggest that a RICO indictment must contain pages and pages of extensive detail about the connection between the enterprise and the pattern of racketeering activity. We hold only that the sparse allegations of this indictment, which says nothing at all about the nature of the connection, are insufficient to enable the defendants to prepare for trial. And in that regard, let's talk about, hey, can you conspire with people that hold guns to scrappers' heads, et cetera? No, but if you're Mr. Liberto, for instance, not picking on your guy, he is named in one overt act, number 143. That on or about January 18th, 2023, he did attempt to occupy the DeKalb forest with camouflage, camping gear, and living supplies. I don't know if you've been out on Martin Luther King Jr. Drive, but there's folks out there wearing camouflage with camping gear and living supplies. So any homeless person in that park should be part of this RICO?
No, Judge, not unless there is.
Not unless there's a nexus to the RICO. Where is it?
In the allegations, Judge?
This was done to prevent the construction of the Atlanta Public Safety Training Center. That's what you're going to point to.
Yes. And the introduction that talks about the direct actions as well as the common purpose. And I'll go back, Judge. If you're going to ask me for a cite, but let me say it and then I'll go find my cite with the court's permission. The bottom line is that one of the things we will have to prove is not that each defendant agreed ahead of time or then later committed predicate acts themselves. So what we will have to prove at trial is that the defendants knowingly joined a conspiracy that they knew had a common purpose of committing predicate acts for the goal of the enterprise in this situation. I'll just apply it to this case. And so an overt act is alleged against Mr. Liberto. That's all we have to allege in the indictment. And again, I'm not saying that the indictment couldn't be better. It could, I mean, of course, I mean, any indictment. But is it sufficient to put him on notice? Yes. The indictment tells him or tells them all that what the DTAF, the Defendant Atlanta Force Enterprise is, where it got its beginning, some of the things that surrounded it, how it's structured, it does allege that, how it is financed, all of that. And then it says, these defendants, each individually and as a group, as parties to the commission of the crime, conspired to commit RICO, and the law will be that we have to establish, and then it alleges the predicate acts. So while I understand that he's charged in one paragraph, that's his overt act. And we allege that it's in furtherance of the conspiracy and that it's in furtherance of the purpose of the enterprise, more important. And Judge, that's what we have to allege. Now, that's not all we got to prove, again, but that is what we have to allege. Does that answer your question?
It's an answer.
Okay. And so as far as going back to the issue of whether there's sufficient do you have other questions about the stuff I've talked about before I move on? The issue of whether there's predicate acts, and we've argued this before, Judge, but let me hit a few more points. One is and Mr. Samuel didn't argue it, but I'll go ahead and point it out, that it is not simply just within count one that the court must look. The court must look to the entirety of the indictment, along with the statute, that State v. Bear 303.
The Kimbrough case that got overturned seemed to say otherwise.
Well, so
It's because that was, the Court of Appeals was like, well, if you look at the whole indictment, you get the main picture. And the Supreme Court said, no, that's not how it works.
So Judge, for example, Sanders, which is a 2022 case, which is cited by the defense, 313 Georgia, 191, 200. When an indictment charges a compound K felony, and maybe that's the issue. This is a conspiracy. Maybe that's the issue. I would need to look back at Kimbrough. I apologize.
Because there, Kimbrough, the Gwinnett County folks took an indictment, they said, and they incorporated counts 5 through 20 and then 25 through, they incorporated the counts into the RICO count. And while the Court of Appeals thought that was fine, the Supreme Court said, we disagree. And I understand the state's argument is, hey, that's why we put all these overt acts into count one.
Put them on notice, and then the elements are filled out with the remaining count, or 2 of them at least. And that's not my only argument, Judge, but Sanders,
Sanders a murder case.
It's okay. Well, so if it's a direct murder, Judge, then the distinction, then I can answer you what the distinction is. The distinction is that when an indictment charges a compound felony, that is different, or a compound crime. And are you looking, should I just hush and let you read Sanders real quick?
I'm listening.
Okay. Basically, Sanders stands for the proposition, and it's well adopted. It's not in question, that when an indictment charges a compound felony, such as conspiracy, the count charging the compound offense must contain the essential elements of the predicate offense, or the indictment must contain a separate count charging the predicate offense completely, or the indictment must elsewhere allege facts showing how the compound offense was committed. And a challenge that a count in the indictment must be vacated because it did not allege the essential elements of the underlying offense is a challenge to the form. Anyway, so in this, we have to prove that the defendant conspired with one or more people to conduct or participate in the defend the Atlanta forest through a pattern of racketeering activity, and that one or more of the co-conspirators committed overt acts in furtherance, which goes back to somewhat of what you mentioned before, Judge. And technically, we don't have to prove that each defendant or allege actually did the overt acts. One of the co-conspirators must do an overt act. So as to Mr. Liberto, and I'm sorry to jump around, but as to your point about Mr. Liberto earlier, we've alleged a conspiracy. So every single one of those 225 overt acts are attributable to him, because once we prove, of course, but in allegation, because he is alleged co-conspirator and he is responsible for the overt acts of his co-conspirators. That's it. Again, we do not have to allege that a individual defendant committed racketeering acts, but rather that the defendant committed overt acts in furtherance of the conspiracy. And those acts don't even have to be crimes. So we do not have to allege or prove that the defendant agreed to that he himself will commit predicate acts. And I'm going to cite it's 2025 Jordan versus State 375. And Judge, I have some of these cases if you want copies, but 375 Georgia App 552 2025 case. That is citing the Cotman case. And Jordan says a person may be found guilty of RICO conspiracy if they knowingly and willfully join a conspiracy which itself contains a common plan or purpose to commit two or more predicate acts. They don't actually have to intend to commit the acts themselves. Now, as to whether we alleged predicate acts, one of the most important aspects of the RICO statute that I think has been missed, and not just by these defendants, but a lot, is that the plain reading of racketeering activity under 1314.3 and its many subdivisions leads to a conclusion that has been adopted by the Supreme Court of Georgia.
1614.3.
Excuse me. I'm probably going to do some things like that. I apologize, Judge. 1614.3. That not every act of racketeering activity actually has to be a full and self-contained crime. And so as the court knows, but I'm gonna go through it for the record, that we have to allege a pattern of racketeering activity. And under 1614.3 subsection 4, we have to allege either at least two acts of racketeering activity in furtherance of one or more incidents with the proper relationship. And I'll just abbreviate it that way. Or we have to allege that they engaged in one or more acts of domestic terrorism. And then racketeering activity. So it's one of two ways. Either it's at least two acts of racketeering activity, or at least one count or at least one accusation of domestic terrorism. So when you come to it, how's racketeering activity? And this is where it gets interesting, Judge. Yes, everybody knows about 1614.3.5a. Everybody is aware of it. It says that racketeering activity includes to commit, attempt to commit, to solicit, coerce, intimidate another person. And then it goes on to say, gives, I think it's 43 categorical or categories of criminal offenses. So for example, assault, and then it'd be any of those assaults under that article and chapter. But that's one way. B is the second way. So 1614.3.5b says that racketeering activity shall also mean any act or threat involving ... So murder, robbery, things of that nature, arson, and felony obstruction of justice is arson and obstruction of justice, which is punishable by imprisonment for more than 1 year. So with the plain reading of that means that if we allege in our indictment domestic terrorism one or more time, two, adequately, two, predicate acts under 5A, which would involve the criminal offenses, or three, acts involving arson or felony arson or felony obstruction of justice. that if within the entirety of our indictment, we have done that, then we survive demurrer. And I'm going to give you the case that specifically says that 5B includes not only, or it adds to the list of criminal offenses by saying acts or threat involving. And that is in 2005, it's Dorsey v. State, 279 GA 534 at 540 through 541. And in that particular case, Judge, the state had alleged multiple different paragraphs of predicate acts and for the racketeering activity. One of those was, I think, paragraph 5. It doesn't really matter. They had a paragraph, and in that paragraph, they alleged that defendant, let me get it right, committed acts involving murder, which is one of the allowed crimes. And then it says, in that he met with 4 co-conspirators for purpose of planning, that the conspirators conducted surveillance and obtained firearms, that Dorsey covered for Cuffey and that when Cuffey was questioned by law enforcement, and that Dorsey employed co-conspirators in the sheriff's office as consideration for their participation, and, lastly, that he discussed alibis. None of those were criminal offenses. And so what the court in Dorsey said was that, and specifically, that Dorsey argued that those were not sufficient because they didn't establish all of the elements of a criminal offense. And the court rejected that and pointed out that 1614, 3.5B includes acts involving. And in saying so, they actually reference and cite to a case, United States versus Miller. It's in the other case, which says, interpreting the federal RICO statute, defines racketeering activities as encompassing any act involving murder to include an act which need not be murder so long as it directly concerns murder. All that to be said, under this acts involving, all right, we do not have to allege that the defendant or defendants committed an act of arson. Though we do allege that, we don't have, that's one way. We do not have to allege as a separate, fully set out accused charge that they committed felony obstruction. Under B, according to the Supreme Court and according to a plain reading of the statute, which differentiates itself from A, we have to allege acts or threats involving a narrow amount of, narrow classification of charges. But one of those charges is arson and another is obstruction with a modifier that it has to be felony. So felony arson and felony obstruction. So, again, I cite to that case as adopting that practical and plain reading of the statute. And so those are the 3 ways we can do it. And so going back to what I indicated earlier, Judge, bottom line is you have to read, the question becomes, is within count 1 or within count 1 referencing other counts, or basically are there facts anywhere in the indictment pulled together that can establish the racketeering activity? And my assertion is that we have done all 3, and just for the record. All right, under 4B, first of all, under 4B, if we have sufficiently alleged domestic terrorism, one time, done deal, pattern of racketeering activity is alleged. You don't have to allege, unlike the other issues, you don't have to allege multiple incidences of domestic terrorism activity. You have to set it out fully and completely, but only one time. And the indictment does so. Section 2, paragraph 152 of count 1, in the overt acts that include predicate acts by the language of the indictment expressly stated, states that on or about January 21st, 2023, Naja Gear, Madeline Fiola, Emily Murphy, Francis Carolyn, Ivan Ferguson, joined the night of rage in Atlanta, caused arson and property damage, and thereby committed the offense of domestic terrorism. Now, obviously, as far as domestic terrorism, that doesn't lay out the elements of domestic terrorism. The state's not saying that. However,
Slow down, Ms.
yes,
Dixon.
I'm going too fast.
You're going too, I know you're going too fast for Mr.
Yes,
Forte.
I apologize.
So you're going to 162,
Yes. Oh, 152.
150. Not to put Mr. Liberto on the spot here. But is it going to make the difference that post dates his 1 day in the park?
Very specific.
I'm sorry, Judge. I apologize. I can't hear
Okay,
anything.
Mr. Liberto is alleged to have camped on January 18th of 2023. This predicate act of which you speak in paragraph 152 occurred on January 21st, after Mr. Liberto went camping in DeKalb County.
Right. It's an ongoing, continuous litany of activity. And so I see what you're.
So how does that tie him in? You got to show how that ties him in, because if somebody goes camping and then 3 weeks later somebody burns something down.
So it's really
So if I go by an Italian ice at a mafia sponsored parade, I'm cooked.
no, no,
Okay.
absolutely not. If there's evidence, however, that beyond what overt act, again, we don't even have to allege an overt act, but we.
I paid $1 for that Italian ice.
Then that might have been a crime, because that sounds really cheap. You know, what they say about, if it's too good. to
It
be
was a
true.
mafia sponsored event.
Okay, but if it's too good to be true, anyway. Sorry. So bottom line is, Judge, no, obviously, because there's no evidence of other, well, if that's all you did, okay?
How's he on notice? That's his point. How am I on notice that camping furthered this conspiracy?
Because he's alleged to have. He's alleged, and it's explained. And now given, there is not a specific for each of these 62 argument or about how the state knows what it knows about Mr. Liberto, for example. But it accuses and alleges, which is what we're here for.
Mhm.
And it says, Mr. Liberto, we are telling you to be on notice that you are accused of conspiring to do these things and to commit this RICO act. And then, of course, how RICO is defined, that comes from the statute, it comes from case law. But maybe this answers your question, I'm not sure. The bottom line is, Judge, he doesn't have to have agreed specifically to certain criminal acts. He has to have agreed that predicate offenses or acts, not offenses, not just offenses, predicate acts will be committed in, these words get so overlapping, but that predicate acts will be committed in pursuit of the purpose of the enterprise. At least 2 will be committed. He has to do so knowingly. And the conspiracy itself or the enterprise itself has to have a common purpose. And that's what we have to prove. So while one overt act is alleged in the indictment, that is not the extent to which the state has accused him of being involved. The state has accused him of conspiring to commit RICO, which 2 or more acts in the indictment. So that's one act. Let me keep going, which is after the fact, but it is a continuing enterprise. And I understand what you're arguing. Your argument is, okay, well, if
I'm not arguing, I'm just
no,
pointing out
excuse me, your
facts.
point is, if he was in the But that's not the only, but again, it's not the only incident that he's aware of, or he was involved in, or that we have information on.
How does he know that
Usually
from looking at the indictment?
because he's accused with conspiring to commit, and that he knows at least two predicate acts occurred, or conspiring to commit two predicate acts, basically. And so that's how he knows, because he's charged with it.
Go on.
And again, Judge, he doesn't.
Hey. You laugh, you leave. It's real simple. It's real simple. Sheriff, next person that makes a noise, gone. You want to giggle out in the hall? Fine. We're not doing that in here. Little decorum, folks.
And people can giggle and people can laugh and.
Not in my room.
Well, they can. Bottom line is, Judge, we don't have to even, we don't have to allege or prove that he committed an overt act. We don't have to allege or prove that he committed a predicate act. We have to allege and prove what is alleged, which are the essential elements of conspiracy.
You don't have to prove that he committed an overt act?
But he or one of his co-conspirators.
So you don't have to prove he did anything?
No, not, well, I mean, not an overt act. No, we do not have to allege or prove he committed it. It's he or any of his co-conspirators. That's the law on conspiracy.
You don't have to prove that Spencer Libero did anything? I think that's a good time
I'm
for,
sorry,
that's a good
predicate
time,
act.
that's a good time for lunch. See
No,
y'all at 1
predicate
o'clock.
act. Let me correct that predicate act.
Sure. After she talks to me.
Sure.
How you feeling?
That's what I'm saying. I don't mind fucking around. I just want to know where people are.
Let's step away from these microphones.
Oh, I don't know. Yeah.
I think everybody was good for.
Oh, yeah, because I keep, now let's see how far you. Yeah, go out there, I'll be right there.
Not yet.
It's optional. More now.
Sound what I wanted to hear.
It is.
Yeah, I got.
Thanks, Carl. Coach Courage takes it. So I didn't get it. I was here till 10 o'clock after we did this stuff. And so I started back, anyway, it doesn't matter after it's. But
I guess the police shooting. Oh, wait. Oh. Cops walk up and blow the guy away.
So they bring something up.
All on video. So
So anyway.
your hands.
Person.
Therefore, I'm not as prepared as I would like to be.
There's days like that, right?
I'm a mess. All right. One, what time is it now? I'm a mess.
Oh my gosh.
Tell me your name.
My name is Rebecca. Procedural.
Yes.
Tony is my son.
He mentioned that you would be appearing with him.
Yeah. Oh, yeah, hi, you're famous.
Oh, you want us out? Okay, my co-counsel's back there. Hang on, let me get my stuff.
Whoever was just would walk out, I just rather everybody just.
2 seconds. No, I'm with you. You're fine. John's in the back.
Anyone leave, so I have to let go.
Just so we're clear, you're talking about federal society in general. I'm with you. All right, so let's just leave the computer. Sorry, I am. John, they've asked us, good golly, they've asked, the security's asked us to step out.
Okay, good. Now, 1 o'clock turns it. We got to walk back up. All right,
We'll just step outside. I'm not going back to the
I'll
office.
leave you that, so aren't you? I might have them. No, that's. I was never I need any.
No, you need to.
All right. He's not just. Oh, all right.
We added arguments to get out of